thank you. The executive committee meeting of Thursday, July 24th is now called to order. It is my duty to remind you of the duty of the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict. Please refrain from participating in any matter where there is a conflict of interest or appearance of conflict. Please note any conflicts at the appropriate time. All right, moving right along. We will now move to the approval of the minutes, the proposed minutes of the executive committee of April 24th, 2025. Excuse me, are posted and shared. Are there any corrections, suggestions, changes? Seeing none, I'll entertain a motion to approve. Have a motion and a second. Is there a second? Second. Motion second, further discussion. Seeing none, all those in favor signify by saying aye.
Aye.
All opposed? Any chair, motion carries. Next item is proposed minutes of the council meeting on April 25th, 2025. Are posted on SharePoint. Any changes to the council meeting? Seeing none, chair will entertain a motion. Motion to approve. Motion to approve, is there a second?
Second.
Motion and second, further discussion. Seeing none, all those in favor signify by saying aye. All those opposed? Any chair, the ayes have it. Moving around, we're allocated financial report. We will have a report of the Finance and Audit Committee. Madam President-elect, Ms. Fry, let's give the report.
Thank you. The 2025 second quarter financial statements are posted on SharePoint. The Finance and Audit Committee has recommended that they be approved.
As a motion from the committee does not require a second. Further discussion. Seeing none, all those in favor signify by saying aye.
Aye.
All opposed? Your chair, the ayes have it.
Next, there is a proposed amendment to the state bar's personnel policies and procedures to align the state bar's paid vacation hours with the state's policy. The Finance and Audit Committee recommends that this also be approved.
Motion for committee does not require a second. Further discussion. Seeing none, all those in favor signify by saying aye. Aye. All opposed? Chair, the ayes have it.
Next, the council is required to approve the election of the state bar external auditor annually. The Finance and Audit Committee recommends the selection of Bernard Robinson and Company as the auditing firm and Sarah Stanley as the accountant in charge.
The motion from committee does not require a second. All those in favor signify by saying aye.
Aye.
All those opposed? Being chair, the ayes have it. Motion carries. We will now move on to appointments. The executive committee submits nominations to the council based on the recommendations of the appointments advisory committee. Ms. Fry.
First, we have the Ielta Board of Trustees. We have 3 appointments to make, each for a 3-year term. Alexander Dale is eligible for reappointment. Shelby Benton and Heather Culp are not eligible. The Appointments Advisory Committee recommends the reappointment of Alexander Dale and the appointment of Anna Hamrick and Tom Nelson for 3-year terms on the Ielta Board.
Without objection, we will consider these as a group, as it is a motion from committee. Motion from committee does not require a second. Is there any discussion? Seeing none, all those in favor signify by saying aye. Aye. All those opposed? And chair, the ayes have it. Motion carries.
The Ielta Board Chair and Vice Chair are also appointed annually. The committee recommends the appointment of Judge John Arrowood as Chair and Ted Edwards as Vice Chair.
Again, the motion from committee does not require a second. Is there any further discussion? Seeing none, all those in favor signify by saying aye.
Aye.
All those opposed? Chair, the ayes have it. The motion carries.
There are 2 appointments to be made to the Board of Legal Specialization, and we must also appoint the board's Chair and Vice Chair. The 2 board members and the current Chair and Vice Chair are all eligible for reappointment. So the committee recommends a reappointment of Julie Beavers and John Bercher to the board, and the reappointment of Matthew Leidenheim and Barbara Morgenstern as Chair and Vice Chair.
Without objection, we will take all 4 appointments in one motion as a motion from the Appointments Advisory Committee. Again, it does not require a second. Is there further discussion? Seeing none, all those in favor signify by saying aye. All those opposed? Chair, ayes have it. Motion carries.
We now need to make one appointment to the State Bar Foundation Board due to the sad passing of Bob Wicker in April. Members of the Foundation Board must be a state bar resident. The Appointments Advisory Committee recommends that Marcy Armstrong be appointed to complete Mr. Wicker's unexpired term, which ends January 31, 2027.
Again, a recommendation from the Appointments Advisory Committee requires no second. Does anybody have any questions regarding Ms. Armstrong? I take that up.
Relax.
For life, I don't think so. Again, motion would be required to a second. All those in favor, signify by saying aye.
Aye.
All those opposed, if you chair the ayes have it, motion carries.
Right. The board member Crawford Cleveland resigned from his position on July 7th, 2025, simply because he has now taken the job, as I understand it,
Thank
or the last year, sorry, in Maine or Vermont, as college captain. So this term expires on January 31st, 2026, and the committee has recommended that last volunteer Paul Taylor be appointed to complete Mr. Crawford's term.
Again, a motion from committee requires no second, further discussion. Seeing none, all those in favor, signify by saying aye.
Aye.
All those opposed, if you chair the ayes have it, motion carries.
Next quarter, we have appointments for the CLE board, the board of law examiners, the client security fund, and the paralegal board. So I'd like everyone to make sure that they, notify anybody in their district and if they may be interested, and that is the report in the 100 committee.
We will now move on to the next item of business, which is rule amendments. We will consider first the proposed rule amendments with the amendments for adoption. These proposed rules were publicly commented in April 2025 for the meeting. No adverse comments were received. Absent any objection, we will consider these proposed rule amendments as an adoption for the group. Number one. This will be different. Number one is going to be. How much is this? Right over here. My fault. Chair overrules Mr. Oden's objection. Thank you. Rules 5.11, rules of professional conduct, rule 1.15-2, general rules. 5.12 is 27 NCAC section 0100, imposition of discipline, finding to be capacity or disability. Number 3 is requirements for program approval. Number 4 is rule governing administration of the client's security fund. Does anybody wish to discuss these in detail other than Mr. Oden? Okay. Seeing none, do I have a motion to adopt all 4 amendments? I have a motion. Is there a second?
Second.
Motion is second. All those in favor, signify by saying aye.
Aye.
All those opposed. Seeing none, can you chair the ayes have it, or name carries. Next, proposed rules for publication. We have proposed rule amendments for publication to the Board of Law Examiners. The summary of these rules are in your agenda, and the supporting information also on SharePoint. Members of the Board of Law Examiners, along with the Director Lee, I never know how to thank you, have joined us via Zoom to briefly summarize these rules and scan for any questions. Welcome to you all. Are y'all online? Anybody for the Board of Law Examiners?
They are, and
They're in the waiting.
they should be in. Damon, you have the speakers on so we can.
I don't think we'll have.
Okay.
Yes, we are here.
Okay, great.
Thank you.
Can you hear us?
Yes, go ahead and present a summary if you don't mind.
Okay. Lee is still, some of our executive committee members are still muted, it looks like. Do you all, my name is Roger Askew. I'm the chair this year of the board, and Lee has prepared a report on the adoption of the Next Gen UBE. I don't know if you all have had an opportunity to see that, but essentially it's a very concise summary of what the board is proposing to do with the bar exam beginning in 2028. The Next Gen bar exam is going to actually replace the present uniform bar exam. And it will also sunset the MBE, which all of us took, the 200 multiple choice questions. So, Lee, I'm gonna ask if you can kind of summarize the rule changes that we think are necessary, and then we can kind of take any questions about the next gen after that.
Sure. And I apologize, I'm having trouble getting my video to come up. Thank you very much to the council for allowing us to give you just a brief overview of the rule changes that we have proposed. You'll see in the proposed rules, all but one of the rules that we have submitted are necessitated by the board's vote to adopt the next gen UBE. As you know from the materials, the board voted to adopt the next gen UBE for a myriad of factors, with the first administration of the next gen UBE occurring in July 2028. That is the latest available opportunity that a jurisdiction can wait to launch the next gen UBE, because the current UBE that is used by us right now is sunsetting with the February 2028 administration. The rules that we have proposed are in effect to clarify that beginning in July 2028, the North Carolina will be using the next gen UBE. The rules also allow for the acceptance of transfer applications from individuals who may sit in jurisdictions that have adopted the UBE and began administering it prior to the time North Carolina will launch. This is to ensure continuity so that in this transitional phase between July 2026, when the UBE is going to be administered for the first time by some jurisdictions, and July 2028, when the final UBE adopting jurisdictions will administer, there is continuity between applicants who sit for the current UBE, which is now called the legacy UBE, and applicants that sit for the next gen UBE. Also, of one particular significance that I would like to bring to the committee's attention are the rule changes that we have submitted that add a decedents, estates, and trusts examination component to the next gen UBE starting in July 2028. As you all may know, just from your materials, there are 9 foundational concepts and principles that will be tested on the next gen UBE, and decedents, estates, and trusts is not one of them. The board, recognizing the importance of decedents, estates, and trusts, and the fact that it is significant to all people, regardless of location, economic status, or any other factor. The board decided that it was important that decedents, estates, and trusts be tested as a doctrinal area, and has voted to add an exam on decedents, estates, and trusts as a licensure requirement when we launch next gen UBE. That decedents, estates, and trusts component exam will be a 1-hour in-person multiple choice examination. It will consist of approximately 25 multiple choice questions. It will be available to applicants 4 times a year, February and July, in conjunction with the bar examinations. It will also be available in May and November as a standalone test. In addition to the rules necessary to implement the next gen UBE, we also have submitted proposed new fee rules, which are necessary due to the increased costs associated with the next gen UBE. The fee adjustment that the board is requesting equates to $175 of an increase for examination applicants. It does not change, the board has not requested any fee increase for any other applicant category, for UBE transfers or for comedy applicants. In addition, the Decedents, Estates, and Trusts examination component will not have a fee if an applicant decides to take that component exam in conjunction with the bar examinations in February and July. And that is, the reasoning behind that is the board is already contracted for the venue space. It has already got its proctors in place. It has already got staffing in place. We have submitted a rule indicating there would be a $100 fee increase, or $100 fee, excuse me, for applicants who wish to take the Decedents, Estates, and Trusts component exam as a standalone test in May and November. And that is to cover the costs anticipated with administering those two standalone tests. Finally, we have submitted a rule that is not related to the next gen UBE, but is in order to comply with recent changes made to the Service Member Civil Relief Act. As I'm sure you all know, those recent changes have provided the opportunity for relocated service members and relocated service member spouses to apply for professional licenses without having to be licensed in a reciprocal jurisdiction and without having to have a prescribed practice time. We have drafted a rule and submitted it for the council's consideration. It has those applicants, relocated service members under the proposed rule, would have an application fee of $1,500. This is the current fee charged to licensed applicants who are applying for admission by UBE score transfer. It is less than the current application fee for applicants applying for admission by comedy, which is currently $2,000. Lastly, that relocated service member and relocated service member spouse rule provides that for the relocated service member spouse, there is no application fee as is currently stated in our current rules. In a nutshell, that's hopefully a 30,000-foot view of the rule proposals. I'd be happy to answer any questions as far as if the committee has any questions regarding the actual next gen UBE itself, the structure, the format. Happy to answer those, and I'm sure the committee is as well.
I'd like to mention one other thing that will change with the advent of the next gen UBE. I'm the chair of the UBE committee of the Board of Law Examiners. Currently, when we grade bar exams, there are 6 essay questions and 2 practice type questions that we grade. And of course, the multi-state is graded by machine, just like it's always been. The 6 essay questions are divided among 6 board members, such that one board member grades every single answer to a given essay question for one administration of the bar exam. And with the long form, the 2 long form answers, the multi-state practice test, two people each grade 1/2 of each answer. So every answer is graded one time by one person. When we go to the next gen bar exam in 2028, assuming that's ultimately passed, we'll be grading in a portal created by NCBE, and all grades are input in real time. And every single answer that is to be graded by the board, and that will be every written answer. We'll not grade the multiple choices, of course. They'll continue to be graded by machine as they always have been, but every other answer will be graded by members of the board. The requirements for grading for the next gen bar exam will be that every single question that's graded is graded twice, once by one board member and once by another board member. If those two grades don't match, then there's an adjudicator who will be the third grader for that question, and the adjudicator decides, what the actual score will be. The net benefit to us and to the people who take the exam will be that at least two, and in many cases, three different sets of folks will have looked at every answer and graded it. And that will eliminate the multitude of requests that we get every year to regrade the bar exams. And as a matter of rule and policy, we don't regrade, but the grading for the next gen will create a situation where every answer has in fact been regraded at least twice and maybe three times, so that there would be no possible need to ever have to regrade one, or to even create a legitimate argument that one ought to be regraded once the final grades are released.
Thank you, Lee. Thank you, Ron. Are there any questions on the folks on board policy?
Yes.
Yes.
What will be the new cost for a first-time applicant to take the exam?
It will be $1,025. It is currently $850.
And can you tell us the basis or how you all arrived at the additional cost of $175 per person?
Yes, ma'am. Roger, do you want me to address that?
Yeah, go ahead.
Okay. With the next gen exam, there are multiple cost areas that are increasing. The test materials themselves are increasing in cost, $13. There also is going to be a new software fee that is charged by NCBE that is not currently charged, and that is $149 per applicant. In addition, this new next gen UBE is going to be entirely computer administered. Applicants will take the exam via a secure streaming browser at the examination venue. Jurisdictions are going to be required to provide continuous Wi-Fi internet connection throughout the exam. As y'all probably know, we use multiple venues to administer the exam. One of those being the Jim Graham Building and the Exposition Center at the fairgrounds. Neither of those venues has sufficient bandwidth for the Wi-Fi connection that will be needed. So the board has requested quotes from third-party vendors as to what the potential cost will be to provide that continuous streaming at the venue sites. That at 2025 costs is, the quotes we received were anywhere from a little over $22,000 per site to a little over 14,000 per site, not including the cost of the actual internet itself. And finally, as Mr. Baker mentioned, the next gen UBE will have to be double graded. At present, we are not certain of whether or not the current board by itself will be able to achieve that double grading and meet the timelines we have, or whether additional graders will be necessary. Hopefully that provides you with some information.
Thank you.
Any further questions for the folks from the Board of Laws? Thank you, Lee, for that presentation. Thank you, Ron. Seeing no further discussion on it or further question, is there a motion to recommend publication of these proposed new rules? I have a motion. Do I have a second? Motion and second. Further discussion? Seeing none, all those in favor signify by saying aye. All those opposed? And chair, the ayes have it, and the motion carries. Thank you, folks.
Thank you.
Thank you.
Ron,
Thank you.
Thank you.
All right, we'll now move on to the reports. First, the chair recognizes Carmen Madden, the report, litigation report.
As you know, I usually would say more than one sentence, however, I do have, a regrettable update to our litigation report. I finally, after 8 years, removed from the report some filed cases against State Bar associated people because no one had ever been served with them. And I thought, you don't need to read this every quarter. On Monday, I received via FedEx a summons and complaint, at my home. So I was a defendant in one of them. I have on good authority that another 2017 lawsuit is currently moving, also filed by this bar lawyer, and I'm not sure yet whether former President Colombo or former Council Catherine Jean has been served, but it appears that we may have resurrected litigation, unfortunately. Other than that, the litigation report is in the materials. I've got some questions.
Personally, I like the shorter version better, Carmen.
What happened?
Any questions, Carmen? Thank you, Carmen. We'll move on to the next report, and that'll be from the Issues Committee. The Right Honorable Judge Todd Brown.
Thank you, Mr. President. Good afternoon. The Issues Committee met yesterday to receive, updates and reports on 3 matters. I'll briefly touch upon those. The first is we heard a report from the Trust Account Rules Subcommittee in the process of being appointed by the president right now. That is a study to be done at the request of the president to look at the trust accounting rules in terms of whether they need modernization or change or whatever. He'll be conducting that probably as it's one of his duties as past president. I think.
I love the sound of that.
So we should have that subcommittee appointed soon, and they should be giving us a report at the October meeting, if not before. The second update we received was on the law school graduate supervised practice rules. We heard about this before. It would permit law school graduates to engage in limited supervised practice at governmental agencies and legal services organizations. That has been, as I recall, published, and we received no adverse comments. However, we require some action by the legislature in order for that to go into effect, and that has not occurred yet. Peter, is that correct?
That's correct. The proposed changes would typically be in front of you today for adoption, but we are going to wait to put that in front of the council until we have received the statutory authority to run the program. So we don't have to submit rules to the Supreme Court that cannot be approved.
And third report we got was from the, joint subcommittee to study the Signal Service Award Committee policy. At that, subcommittee was appointed to study and propose a formal background check process for nominees for the John D. McMillan Distinguished Service Award. I believe they had a meeting, they did have a meeting about 15, and they're continuing to work on a policy that would be presented to this body for consideration at some point. And with that, I believe that concludes, the report, Mr. President.
Thank you, Judge Brown. We will be working on the trust account planning and appointing a committee. We just, I hope that has taken my attention the past couple of months. Moving on, report of the AP committee, Judge Blaylock.
Hey, everybody. All right, so we met yesterday, and the committee reviewed 10 complaints regarding the unauthorized practice of law. The committee dismissed 4 matters, voted to issue 3 letters of caution, voted to take no action on 1 matter, and voted to continue 2 matters. Council provided an update on the progress of a subcommittee studying an advisory opinion about the scope of permissible activities for non-attorney special education advocates in administrative proceedings before the Office of Administrative Hearing. Council also requested that the Authorized Practice Committee form a subcommittee to revise the guidelines for attorneys licensed in other jurisdictions. In closed session, we were updated by council, regarding the status of an injunction filed against Cypress Sydney Acute McDaniel, which was ordered against Ms. McDaniel last month. And regarding the prepaid legal services plans, council advised the committee about the state bar receiving no proposed amendments to existing prepaid legal services plans during the second quarter of 2025. And the state bar received 3 initial registration statements during the second quarter. Prepaid Legal Services Incorporated, One Choice Legal Plan, 25 PPO5, Select Legal Plan, 25 PPO6, Select Plus Legal Plan, 25 PPO7. The state bar issued 1 notice to show cause, while plan registration should not be revoked during the second quarter to Discount Legal Plan, 21 PP15. And notice was sent out in March 28th, but it expired after the April 2025 meeting. And so the plan is being presented for revocation, at this meeting, the July meeting. And we issued no orders of revocation during the second quarter of 2025. For an action item, the staff council proposes the committee recommend the council issue an order of revocation for Discount Legal Plan 21 PP15.
That's the only action item.
That's the only action item.
All right, we do have an action item to revoke what she said. What was the name of the company?
Discount Legal Plan.
Discount Legal Plan.
15.
Are there further questions on that? As it comes from committee, it does not require a second. All those in favor signify by saying aye. All those opposed? Chair, the ayes have it, and the motion carries. Anything else, Judge? Thank you. It was noted to me that, we forgot to find folks at admin. So I'm gonna work them in now and have a report from the admin committee and Judge Ray.
Administrative committee met yesterday. We had 69 lawyers were transferred to inactive status. 1 was granted upon satisfying certain requirements, 2 were granted non-proton. We had 1 petition for emeritus pro bono status for inactive matters that was granted or recommended to be granted. We had 14 lawyers who were granted reinstatement from inactive status. Of those, one of the petitions was deferred, and 1 was approved upon the condition that they satisfy the bar exam requirement. We had 5 petitions for reinstatement from suspended status. 4 of those were granted, One was deferred due to a pending grievance matter that needed additional investigation. We have one petition for relinquishment of membership. We had 4 petitions for pro bono practice by out-of-state lawyers. All those were approved, they met the conditions. And then there will be attached to the materials a notice to show cause and suspension order list, which is fairly lengthy. And Tammy and Nicole and Lauren intend to send out an email the first of the week to all members of the council with recommendations on information to provide to attorneys in your district who are on the list of American.
Thank you, Mayor. Appreciate all your hard work on that. We'll move on to the next committee report. That'll be Communications Committee. Mr. Davidson.
Yes, communication committee met yesterday and we communicated, that's the end of the report. I'm just no, purpose of the communication committee, of course, was when I first got on it, I didn't know exactly what it was, but it's to advise the bar on how to better communicate, and disseminate information about the action of the state bar. And yesterday we met, one of the things that was outstanding, was the publication and communications committee are now merged. And during the meeting, we discussed, of course, journal policy edits, how we navigate screen articles that are set to be published. We talked about the upcoming fall edition and also proposed articles, that some people would like to see, which would be like, for example, articles on policy, which seems to be this creature that's coming up in some of our counties starting in October. Mr. Kozisi, provided information on, the website updates, talked about some of the most, visited most visited pages on our North Carolina State Bar web page. And we are on schedule or on track for our next year. The action item that we voted on, and thanks to Governor Ms. Radler, was the approval of the fall edition is actually coming out, and that was approved. And that will be the report of the communications committee. See, we did.
Wonderful. Thank you. Next, we'll move on to Fine Folks and Ethics. Judge Dorothy.
Good afternoon, everybody. We met today, earlier this morning, and as always, had a really good meeting. We got a report on our administrative matters, of course, on trust account audits, ethics phone calls, report on COE presentations, all of those matters. And we have 4 pending inquiries, inquiry of Kemp, public defender offices in the Moulton County District, real estate client referrals to law partner business, and a reconsideration of a prior published opinion, client consent to annual rate increase. Those are returning to subcommittee. And then we have 1 new inquiry, which is an inquiry of grievance, non-disparagement clause, and fee agreement, or as a condition of a fee dispute resolution that is a new inquiry and we're sending to subcommittee. So all of those will go into subcommittee. We'll continue that great, robust subcommittee work as always in between meetings, quarterly meetings. And then we have 1 action item that we're seeking for approval to transmission to the council for adoption, and that is the proposed 2025 FEO2 negotiating licensor reporting capability during mediation.
That is an action item. Thank you. That is an action item. Any questions regarding that? I think it's in the materials. I'll just be quiet. Get ahead of myself. Since Peter's talking to me, Peter, it's your turn. Sure.
Yeah, what's going on over at the legislature?
Not a thing.
I want to give an update on a number of matters that are going on at the legislature related to the state bar. And to start with, as Todd mentioned, the law school graduate supervised practice rules required an amendment to Chapter 84 to permit the state bar to allow law school graduates to participate in supervised practice after, pending the bar, passing the bar examination. That language was in a bill that passed the Senate unanimously. It was then, before it passed through the House, that part of the bill was removed. And so it did not pass both chambers. We're still working with the House to try to resolve this to get that language in place, it seems very clear, obviously it will not be in place before, the results of this July bar exam come out. So, we will be working on this to try to have something in place for those who have, may be eligible for this program after the February bar exam. There was, we also had a amendment to the jurisdictional authority of the, state bar, discipline process to make it clear that the state bar, has jurisdiction over out-of-state lawyers who are within North Carolina practicing law. And that amendment to that language in chapter 84 was passed by both houses and signed by the governor. We worked with the Office of Counsel to get that language correct and that passed through without issue. Earlier this session, there was in the technical corrections bill, the extension of the State Bar Review Committee. I believe I probably mentioned this in April, but that review committee was extended through December 31st of 2026. So we will be prepared to participate in that process when and if a meeting is called for that State Bar Review Committee. Not entirely clear exactly which specific topics they will want to address, but we'll be prepared to work with them and participate as necessary. The main issue that we've been spending all of our time and focus on is the potential threats to the IOLTA program and the funds of the IOLTA program. So in the House version of the budget, there was a provision that would direct all of the funds of the IOLTA program and any incoming funds from interest earned on trust accounts to be remitted to the Office of Indigent Defense Services to go to the PAC fund, the Court Appointed Counsel Fund, for both the current year, but also going forward. And that took us a little bit by surprise, but we reacted and worked with, engaged Mary, Irvine and I were engaged with all of our, the board and the grantees and the officers and the legislature and other interested and involved stakeholders here to try to figure out where this was coming from and what we can do to try to resolve the situation. That House budget, like the Senate budget, they are incongruent and they have not passed and there is no budget in place. And it does not appear to me that is moving anytime soon, that particular language. So, then about a month and a half ago, about a month ago, there was, the last day of legislative session before they started taking more and more summer recesses. There were a number of bills being pushed through and there were, 3 bills that were passed by the House and sent back to the Senate with amended language in it that all contained the same language that essentially prohibited the IOLTA board from making any new grants or paying any money out that hasn't already been paid out as of July 1, 2025 through December 31st, 2026. So a year and a half freeze on making grants. And this was again something that we worked through as hard as we could. One of those bills did pass the Senate and signed by the governor, and so that is law. Right now, there is a freeze on IOLTA's ability to make any new grants or spend any funds that come in through interest earned on trust accounts, other than the ability to pay for administrative costs, staff, salaries, those types of things can still take place. So we are working very hard on this. There are some matters that are of confidential nature that I can expound upon in a closed session. But I'm optimistic that we're working with the House and other leaders to try to find a resolution here to be able to resume grants. There could be potential changes to processes and rules that we will have to look at. But it is, my hope that we will be able to resolve this in time to be able to make 2026 grants. And we will continue to be working on this night and day. Mary has been phenomenal, the team has been phenomenal and, resolute. And we want to do the best of, whatever we can do to preserve the great mission of IOLTA, which is providing funding for access to civil legal services for those who can't afford. So we're working on it, and I think that, I will share any, be able to potentially answer some questions and share some additional information.
Thank you, Peter. I will now move on to Judge Cobb, and I believe the Honorable Judge Cobb may have a motion.
At this time, Mr. President, I would move to go into closed session pursuant to General Statute 143-318.11A2 and A3.
Thank you. That is a motion to go into closed session. Is there a second?
Second.
Have a second. Is there further discussion? All right, we're back in open session and we are live again. Judge Cobb, you have your motion.
Yes, sir, Mr. President. I move that the executive committee approve the nominations of candidates A and B discussed in closed session to be presented to the full council for presentation of the John B. McMillan Distinguished Service Award, subject to our standard due diligence checks.
Motion for committee does not require a second for discussion. Seeing none, all those in favor signify by saying aye. Aye. All those opposed. The chair ayes have the motion carries. Is there any further business to come before the executive committee? Seeing none, Mr. Bachman, I move we adjourn. Motion second. Hey. No objection, acclamation.